Please, court's back in session.
All right, thank you. You can be seated.
Afternoon, Your Honor. Afternoon, Your Honor.
Afternoon.
Hey, Mr. Alfred, come stand over here. I'm Jay Williams. I'm not going to be representing you ultimately, but I'm going to be representing you for this bond hearing today, okay?
All right, State of Florida versus Alfred, 26 CF 1167. We're here for a pretrial detention hearing. It's my understanding the state's not going forward on that.
That is correct, Your Honor.
All right, so we just have a bond hearing. Mr. Williams?
Yes,
Here on behalf
sir.
of Mr. Alfred, who's present.
Yes, sir. Judge, you want to put Mr. Alfred under oath for the bond information?
All right, Mr. Alfred, raise your right hand. Do you swear or affirm any information or testimony you give today will be the truth, the whole truth, and nothing but the truth?
Please state your name for the record.
Willard Alfred.
Mr. Alford, how much bond do you figure you can make?
Up about $1,000.
Do you mean you could pay $1,000 to a bondsman?
Yes, sir.
Okay. All right, so that would be a $10,000 bond. Mr. Alford, if the judge puts restrictions on you, orders you to stay away from this location, stay away from these individuals, are you going to be able to comply with that?
Sure.
All right. Now,
I didn't hear an answer.
I'm sorry, would you say that again a little louder?
Yes, sir.
I saw you nodding, but I didn't hear it. I just want to make sure it gets picked up by the microphone.
All right, and Mr. Alford, how long have you lived in this area?
All my life,
Okay.
60 years.
Are you currently employed
I was until the other day.
until this arrest?
Yes, sir.
And, sir, if the judge lets you out of jail, where are you going to be staying?
I can go back to Ponce de Leon with my girlfriend.
Ponce de Leon, Florida?
Yes, sir.
Are you going to be able to make it back for your court appearances?
Yes, sir.
Are you currently working?
Yes, sir.
Well, you said you were
I
working.
was.
Do you think you can get your job back?
Yes, sir.
Judge, I don't have anything further.
Okay. Any other evidence at all?
No,
Other
Your
side, Mr. Sheik? Just argument?
Yes, Your Honor.
All right, go ahead with your argument, Mr. Sheik.
Yes, Your Honor. First appearance paperwork shows that there's 5 different failures to appear. We even have in Okaloosa, or in, I believe Okaloosa, but definitely in the state of Florida, I know, a conviction for a felony failure to appear. On top of that, there's 2 different escapes that he has been adjudicated guilty on in his criminal history, Your Honor. He also has a history of violent felonies, included aggravated assault with deadly weapons, has that twice, aggravated battery on a pregnant person, and battery on law enforcement officers. Additionally, the facts in this case are we have a witness plus the victim, and according to the testimonies that we have in that, it was just an unprovoked battery going into the individual's domicile at that time, and therefore the state would ask for a minimum of $100,000 bond, Your Honor, plus the standard conditions that would go with this charge.
Judge defense would ask for a $10,000 bond with those same conditions.
I'm looking at a pretty extensive criminal history, and as the state has brought up, 2 prior convictions for escape, failures to appear, DUI with serious bodily injury, grand theft, a couple simple batteries, grand theft motor vehicle, aggravated assault, aggravated battery of a pregnant person, cocaine, controlled substance, armed trespass, battery on law enforcement, burglary. It's pretty extensive. I'm just looking, and that's just what I'm pulling from his prior prison history,
Yes, sir.
including a recent 10-year stint where he just was released in 2023. Any other argument?
No, Your Honor.
All right, this would be $50,000 cash or professional, no contact with the victim or any witness. Don't go back within 500 feet of his residence. That's the victim. If he's to be released, he'll be with a GPS monitor. He'll have to meet with pretrial supervision once per month, call in every week. No possession of any firearms. That should be a given the criminal history and felony convictions, but no possession or use of any firearms or weapons. Anything else, Mr. Sheik?
No, I think that's it.
All right, thank you, Mr. Alfred.
Yes, sir. Sir, your regular public defender will be out to see you soon.
Well, Mr. Maddox, do we have Miss Green?
Luckily, Rihanna Green, and she does still want to enter it.
Okay, let's get Green done, and
Thank you.
then I'll do the whole announcement for the 1:30 docket.
All right. Hey, Mr. Green. All right, Your Honor,
Go
this
ahead,
is Ms.
Mr.
Green, 23 CF 2104. I had spoken to her about what we discussed with probation previously. Having been advised as to the implications, she still wants to enter this plea. She understands it will be her responsibility to make sure she complies with probation. If I may approach, Your Honor.
Yes, sir. All right, Ms. Green, I think I swore you in already, but let's just make sure of that. Can you
Yes,
raise your
sir.
right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Ms. Green, you're here in 23 CF 2104 with a violation of probation. I've been given a plea agreement that calls for you to admit to your violation of probation. It will revoke and terminate your current probation, adjudication of guilt, $100 VOP fee, $150 cost of defense. Then you'll start a new term of probation for 2 years, where you're to complete a substance abuse evaluation and any recommended treatment. The costs from your prior probation will be paid during the new term of your probation. Understand?
Yes, sir.
Okay. And I know we talked about it a little bit before, and you talked about it with probation and some family that was here as well.
Yes, sir.
Because you're trying to move back to Alabama, they'll do an expedited transfer, but you got to stay in Florida until that gets done. You
Yes,
understand
sir.
that?
Yes, sir. I have family that lives here. Yes, sir.
Okay. All right. Did you have enough time to go over this plea agreement with your lawyer?
Yes, sir.
Did you understand it? Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Has anyone forced, pressure, or threatened you in any way?
No, sir.
I think I skipped a part. Are you currently, did I ask if you were suffering from any mental health?
I can't.
You can answer that honestly.
Okay. I have bipolar.
Okay.
I am bipolar, but
All
I'm on
right.
medication.
Do you take medication for
Yes,
that?
sir. Mhm.
Do you feel like it works for you?
Yes, sir. It
Do you
does.
feel like you understand what's going on here?
Yes, sir.
today?
I absolutely understand.
That's
Yes,
fine.
sir.
I mean, there's nothing wrong with those issues, Ms.
Okay.
Green. I just want to make sure that it's the medication's not potentially fogging your mind a
No,
little
sir.
bit and you don't know what's going on here.
No, sir.
Okay. You seem pretty lucid to me, and I'm sure Mr. Maddox, your attorney, would agree with that.
Yeah, she is, Your Honor.
Okay. All right. Now, going back to where I was, has anyone promised you anything other than the terms of the agreement I read to you?
No, sir.
All right, do you understand that by entering an admission to your violation of probation, that there won't be an evidentiary hearing where the state would have to prove how you violated?
Yes, sir, I understand.
Okay, and do you understand that you'd be waiving any potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right. And what is your plea to the violation of probation?
Admission?
Yes, that's correct.
And Your Honor, I didn't have it on that plea form, I apologize, but we would just ask the cost of supervision be waived since she's represented by the public defender.
I will waive cost of supervision. Ms.
Thank you.
Green, I'm going to accept your admission as freely, voluntarily, knowingly given, adjudicate you guilty, revoke and terminate your previous probation, $100 VOP fee, $150 cost of defense, and then you're going to start a new term of probation now for 2 years. You're to complete a substance abuse and evaluation and any recommended treatment. Costs from your prior probation will be paid during your new term. I don't have any objection to you transferring your probation to the state of Alabama.
Thank you.
As was discussed earlier I guess it was still this afternoon, but on our morning docket. And then I'll waive cost of supervision due to the fact that you're been declared to be indigent and are represented by the Public Defender's Office. See, this is a downward departure. I think we talked about that earlier today too, but the reason for the downward departure? Anybody?
It was uncoerced plea, as far as I know, Your Honor, legitimate plea bargain.
Plea bargain?
Yes, it was just the plea bargain.
Okay. Uncoerced plea bargain is the reason, just so you understand, Ms. Green, you scored 13.8 months. So the reason you're not going to prison today
Yes, sir.
is because the state agreed to give you another chance.
Thank you.
And just understand that if you were to violate your probation again,
Sir.
you get more points, so that score is only going to go up.
Yes, sir.
Depending on how you violate.
Yes, sir.
So let's not do that.
No, sir. Thank you
So
so
what I need
much.
you to do, Ms. Green, is turn around and speak with probation.
Yes, sir,
He's sitting
thank
there
you.
behind you. Do we need fingerprints or no?
Yes,
We-
you will,
We need
Your Honor.
fingerprints because it's a felony conviction. So talk to probation, then come up here, make sure you get fingerprinted, then they'll bring you back to the jail so you can get out processed.
Yes, sir. Thank you very much.
You're welcome.
All right, good luck, Ms. Green.
Your Honor, the supervision fees are waived,
Yes.
and she will.
I don't know if Alabama will do that, right?
Yeah, I'm not worried about Alabama. And she will be required to pay the, I think it went to.
125
Yeah.
transfer fee.
One-time transfer fee.
Yes.
All right, thank you. Thank you, Your
All
Honor.
right, thank you, Ms. Green, good luck. All right, so we're 1:30 exactly, how about that? All right, everybody, I'm Judge Oberliesen, this is our arraignment docket, so these are new cases that are on their first court appearances. What I'm gonna do is go through the docket alphabetically. I'm gonna call each case up, so just gonna be prepared for who's gonna be next. I'm gonna try to announce two, so you always know who's next. When I call you up, come up to this podium on my right side, your left, the one that you just saw those folks standing at. And I'm gonna, number one, make sure I know who you are. Two, tell you what your case number is and what you've been charged with. You're gonna get handed a copy of a charging document called an information. If you have an attorney, they'll probably take over from that point. If you don't, I'm gonna ask you if you plan to hire one or if you'd like me to appoint you one. And then if there's any discussion of plea offers, that can happen with the state, but that's not necessarily happens all the time, but just be prepared for that could happen as well. You don't have to make any sort of plea other than guilty, no contest, or not guilty. If you want to have more time to think about things, you can certainly plead not guilty and we'll give you a new court date. All right, Ivan Bermudez.
No process filed yesterday. Was that out-of-state fugitive?
Oh, out-of-state fugitive, okay, so that's dismissed because he's been released. All right, Carl Bowen. And Mr. Bowen will be followed by Nicole Brannon. The second person, just stand at the rail there and I'll call you back up when the next or the previous person's done. Are you Mr. Bowen?
Yes, sir.
All right, Mr. Maddox has been assigned to your case from the Public Defender's Office. This is 26 CF 978 where you're charged with aggravated assault. Do you understand that?
Yes, Your Honor. We'll enter a plea of not guilty and demand trial by jury at this time.
All right, you've been given a copy of the information, is that right, sir? It's in your hand there.
Yes, Your Honor.
Okay. All right, and we'll put you on August 24th at 1 PM for your pretrial conference. Stay in touch with Mr. Maddox and we'll see you back on that date. All right, Nicole Brannon. Well, Ms. Brannon, let's make sure everyone's in the courtroom at the time that we start. Because you just missed everything I advised everybody before you started. All right. Ms. Brannon, you're here on 26 CF 1010, where you're charged with possession of a controlled substance, which is a third-degree felony, as well as driving while license suspended with a prior conviction, which is a first-degree misdemeanor. Do you understand that?
Yes, sir.
Were you just handed an information, a charging document? It looks like you were.
She was, Your Honor.
You're appointed the public defender, which is Mr. Maddox. Go ahead, Mr. Maddox.
Thank you, Your Honor. One to a not guilty plea and demand trial by jury.
Ms. Brannon, your next court date's going to be August 24th at 1 p.m. We'll see you back on that date, but stay in touch with Mr. Maddox so he can help you with your case.
Yes, sir.
Make sure you're here on time. All right, Castleberry. All right, are you Mr. Castleberry?
Yes, sir.
Okay, Mr. Castleberry, you're here in 26 CF 982. You were just handed in information showing that you've been charged with burglary of an unoccupied structure, which is a third-degree felony, grand theft, third-degree felony, as well as criminal mischief, which is a second-degree misdemeanor. Do you understand those things?
Yes, sir.
Okay, and can you afford an attorney to represent you in this case?
No, sir.
All right, I'm going to go ahead and appoint the public defender. Mr. Maddox is here from the public defender's office.
Your Honor, at this time, we'll enter a plea of not guilty and demand trial by jury.
Okay, and I will tell you, 2 days ago, when he was unrepresented, he did file a motion to modify or set bond.
Okay.
What is his current bond?
Saying he doesn't think he did, Your Honor. Not saying you're wrong, I just want to make sure.
Oh, did someone do it for him?
I don't know.
I've had help writing.
Oh, you wrote it, so you did file.
I've had help writing.
Okay.
Did you send it to the clerk's office after that?
Yes.
Oh, all right, never mind, I apologize.
It's fine. There's not a whole lot to it. It just says motion for bond reduction, and it says, I've sent a copy to the state attorney's office as well as the clerk's office. That's all I've
I
got.
refused it, but I didn't let me get an option to do it.
All right, but we're not going to address that today. Mr. Maddox can certainly file a bond motion on your behalf and get that set for a hearing.
I certainly will take a look at it and get it set if need be, Your Honor.
Judge, just for point of emphasis, there are two other co-defendants, I believe, with him, so I don't know how many of them are being appointed to the PD, but.
Well, I'm going to appoint everyone with the PD, and then they'll have to determine who they have a conflict with. I don't want to make those decisions so that I then find out that whoever I make sure you stay with, Mr. Maddox, ends up being someone you have a conflict with too.
Yes, sir.
So everyone will get the PD today.
All right.
All right, we'll see you back. We're going to put you for August 26th at 9 a.m., Mr. Castleberry. That's your pretrial conference, but like I said, you'll talk to Mr. Maddox. He can get a bond motion filed if you feel you want him to do that still, and set it for a hearing before that date.
Yes, sir, please.
All right, we'll see you back on August 26th.
Yeah.
All right, Tyron Claiborne.
A few days.
Thank you.
After Claiborne, it's going to be Shane Collier. All right, Mr. Claiborne, you're here in 26 CF 913, where you're charged with smuggling contraband into a detention facility. Do you understand that charge? All right, Mr. Maddox, you're appointed.
Yes, Your Honor, we'll enter a plea of not guilty and demand trial by jury at this time.
All right, I do see a motion to transfer has been filed in his case because he has a pending case in front of. It would be Division 1, so that's Judge Clark. So I'm going to give you a court date because, well, here, I do have an order. It looks like August 12th is going to be your court date in front of Judge Clark. I'm signing that order, transferring you there, just so you have all your cases are in one courtroom with one judge, one prosecutor.
Okay,
I'm
thank you.
saying I can't have it where it's here instead of.
No, it goes to the one where you have the oldest case number.
Correct.
Okay.
Thank you, sir.
All right,
Judge, what
August 12th. Say again.
time is the date with Judge Clark?
It should be, well, let me just make sure that's the right date, to be honest with you, because Hold on just a second, Mr. Claiborne. Let me pull up a calendar here. I want to make sure it's the Wednesday date, not the Monday date.
I'm just gonna enter guilty for you, okay?
Yes, that's correct. August 12th, so it'll be 9 o'clock.
All right, thank you, Your Honor. This is Mr. Shane Collier, Your Honor, 26 CF 991. He's been given a copy of the information. We'll go ahead and enter not guilty plea at this time and demand trial by jury.
All right, it's going to be 8/24 at 1 o'clock, August 24th, 1 o'clock. Stay in touch with Mr. Maddox, he's your lawyer, and we'll see you back on that date. All right, Ralph Conklin.
No information.
There's no information for him, of course not. Does the state have an information from Mr. Conklin? I know there should be one.
I show one in my file. Did I do it? I didn't print one off.
It's driving license suspended, habitual. Third. Good afternoon. Your name, sir?
Shadi Faki on behalf of Mr. Conklin.
Okay. And they're going to try and print out a copy of an information for you. It looks like it.
We don't necessarily need that. I had an extensive conversation with
Okay.
Mr. Mull about this case, as well as Mr. Conklin. He's aware of the charges. We're actually tendering a plea today, if Your Honor would allow him to do so.
Okay. Do you have a plea form?
I do, ma'am.
Oh, yes. Well, I definitely need to make sure there's an information file before I can take his plea, but, well, there's no terms. In fact, it doesn't even have the charge on here. Why don't we do this? Why don't y'all make sure you get all that together? Is it going to be to the felony charge?
It is two felony charges. Right in the right.
Hold on, just,
Special conditions.
yeah, we do it a little bit, but just, what I need is, there's no defendant, and then we put the terms right there as well, just to make sure it's uniform. If it's going to be a felony, I certainly need guidelines as well as the information, Mr. Mall. We'll recall you really quickly, and we can take care of that today.
Thank you.
All right. Once y'all are ready with that, just wave at me, I'll bring you back up. All right, Caleb Crooks, inmate? Yes, sir. That's the information, you can't take that.
Take that in court.
Yeah, I got a couple quick ones, yeah.
Can you show that that information's been e-filed? Once you,
It says it has, I don't.
Up to see, okay.
because that one doesn't have like a e-filing stamp on it, so I just want to make sure, because the clerk can't take the written one as the original, or this copy as an original. All right, we'll get back to it. All right, Mr. Crooks is here in 26 CF 966, burglary, unoccupied structure, grand theft, criminal mischief.
Yes, Your Honor, correct. He's been provided a copy of the information. We'll go ahead and enter a not guilty plea at this time and demand trial by jury.
Okay, and is this one of the co-defendants we had talked about?
Yes, Your Honor, it is.
All right, I'm going to appoint you the public defender, Mr. Crooks. I'm going to give you a court date of August 26th at 9 o'clock. That's your pretrial conference. There's a chance you may end up with a different lawyer than Mr. Maddox, because there's some co-defendants and they have to determine who they're going to keep and who has to go on to a regional office, a conflict counsel, or a private lawyer. But we're going to keep you on for August 26th at 9 o'clock. All right, thank you.
You're good, sir.
You can go now. All right, Elijah Daniel. And Elijah Daniel's going to be followed by Nadine Daniels. All right, Mr. Daniel, you're here in 26 CF 902. You've been handed information. It looks to be possession of marijuana with intent to sell or distribute, as well as possession of a controlled substance. Do you understand those charges?
Yes, sir.
All right, you don't have an attorney at this time. Can you afford one, or would you like me to appoint you one?
You appoint me one.
All right, so I'll go ahead and appoint the public defender to represent you in this case. That's going to be still Mr. Maddox.
Yes, Your Honor.
What would you like to do?
Your Honor, at this time, we'll enter a plea of not guilty and demand trial by jury.
All right, Mr. Daniel, you're going to come back for a pretrial conference on August 24th at 1 o'clock. Stay in touch with Mr. Maddox, and we'll see you back on that date.
Thanks.
All right, Nadine Daniels. She'll be followed by Javon Davis. Ms. Daniels, you are here in 26 CF 995, where you're charged with child neglect, DUI, and DUI refusal, or refusal to submit to testing. Do you understand those charges?
Yes, sir.
All right, Mr. Maddox, you've been appointed previously.
Yes, Your Honor, that's correct. Will enter a plea of not guilty at this time and demand trial by jury. If you could stick around.
All right, it's going to be August 24th at 1 o'clock. Ms. Daniels, stay in touch with Mr. Maddox, and we'll see you back on that date.
Okay, thank you.
Thank you. Javon Davis, followed by Alfonsia Epps. This is Javon Davis, correct?
It is, Your Honor. You, Mr.
Okay, and
Davis.
he's
Yes,
here
sir.
in 26 CF 855, charged with fleeing to elude and drive while license suspended.
Yes, Your Honor, will enter a not guilty plea at this time and demand trial by jury.
August 24th, 1 o'clock will be your pretrial conference. Mr. Davis, stay in touch with Mr. Maddox, and we'll see you back on that date.
Thanks, Your Honor.
All right, Epps. Mr. Epps will be followed by Lecter Fallardo Castellanos. All right, Mr. Epps, you're here in 26 CF 1014, charged with drive while license suspended with prior convictions. It's a third-degree felony. Do you understand that?
Yes, sir.
All right.
You have your
Is
information.
he already appointed?
I don't have an information for him.
You don't have an, is there an information from Mr. Epps?
There is not, because they're all out of state, and I don't know that I can prove the prior convictions. They're from the state of South Carolina, so I'm waiting to see if I get certified copies of convictions and prints with all of them before I'm going to file onto it as a felony.
Okay.
He does have 3 priors, but they're all from South Carolina, and I don't know whether,
You want to offer a misdemeanor day to resolve it? We'll take it.
do that.
You'll do that?
Yeah, and to get it out,
Time served?
time served.
Court costs?
He needs to get
300 in court
and
costs.
He needs to attempt to get his driver's license.
Yeah, he's wanting to. I talked to him about it. All right, we'll do that, Your Honor.
All right, well, write that up, and I'll take you back later.
I certainly will.
All right, Mr. Epps, they're going to write that up, and you'll be able to enter your plea, be done with your case today.
So we can contact him.
All right. Fallardo Castellanos. All right, we have an interpreter. Can you raise your right hand? Do you swear or affirm that you're going to interpret to the best of your ability what everyone says today from English to Spanish? All right, thank you. All right, sir, you're here in 26 CF 968, where you're charged with aggravated battery with a deadly weapon. It's a second-degree felony.
Yes, Your Honor, that's correct. He's been provided a copy of his information. I've also gone over the charges with him pretty extensively at this point. Went to a plea of not guilty and demand trial by jury at this time.
All right, sir, your next court date's going to be August 26th at 9 o'clock. Mr. Maddox will come out and talk to you.
Up to that, Your
Thank
Honor.
you, good to see you.
See you later.
All right, Jose Figueroa. And Mr. Figueroa will be followed by Cynthia Gallardo.
Don't have information for Figueroa.
Your Honor, this is Mr. Figueroa, present and approaching 26 CF 970. We're going to have a pretrial intervention agreement resolution to this. Mr. Mall, do you want me to just put him on miscellaneous 730?
That'll be fine. There's some stuff that we have to discuss, and I got to get with the victim onto it. So
Don't want
Okay, no worries.
7:30.
730? Okay.
Well, I've got to put him on for another arraignment, and I've got no information.
Oh, that's true.
Can we get it done by 7/9?
7:09, yes, Your Honor.
All right,
Can you-
July 9th at 1:30.
Okay. At 1:30? Get it worked out like we talked about. Thank you, Your Honor.
All right, we'll see you back on that date, sir. Cynthia Gallardo, followed by Darren Hawkins. Ms. Gallardo, you're here in 26 CF 1053, charged with possession of a controlled substance without a prescription, third-degree felony.
Yes, Your Honor. Winter, not guilty plea at this time. Trial by jury. She has been provided a copy of information.
All right, Ms. Gallardo, we'll see you back on August 24th at 1 o'clock. Stay in touch with Mr. Maddox. Thank you. All right, Darren Hawkins. Is Mr. Hawkins here? ROR bond. All right, I'm looking at his arrest paperwork. It shows his court date to be today at this time in this place. Any
Yes, sir.
contact with him by any chance, Mr.?
No, Your Honor, we didn't have a number on his first appearance sheet, so he wasn't somebody that I could call, and he's not scheduled an appointment.
All right, state.
I filed the information onto it. I have not heard anything from.
What would you like me to do based on the fact that he's not here?
here. Ask for a KPS, Your Honor.
Okay. All right, I'm gonna, let's see. As he was disruptive at first appearance. KPS, no bond. All right. Conordo House, am I saying that right?
Yes, sir.
Oh, he's been
Canordo.
made.
Hey, Mr. House.
Mr. House, 2026 CF 993. It's DUI third within 10 years, driving while license suspended prior conviction, refusal to submit to DUI testing, possession of paraphernalia, resisting without violence, and a financial responsibility violation. Mr. Williams.
I'm going to enter a plea of not guilty on his behalf, 15 days for any pre-arraignment motions, trial by jury.
All right, August 26th at 9 a.m. for your pretrial conference, Mr. House. We'll see you back on that date. All right, Jesse Howell.
Definitely.
Jesse Howell will be followed by Alicia Hutto, who's an inmate. All right, Mr. Howell is present. He's here in 26 CF 933, charged with grand theft.
Judge, we've already filed a motion to withdraw on Willard Howell, their co-defendants.
Okay.
Has the court received and signed off on that?
On Willard? I don't think I have that one on my docket.
All right, then, Judge, I'll enter a plea of not guilty on Mr. Jesse Howell's behalf, request 15 days pre-arraignment motions and trial by jury.
It's going to be August 24th at 1 o'clock. Mr. Howell, stay in touch with Mr. Williams, and we'll see you back on that date.
Sir,
All right.
do you have a card, Mr. Williams?
I sure do.
Alicia Hutto is incarcerated.
Ms. Hutto's in lockup.
Yeah, she's coming up.
Hey, come on out, Ms. Hutto.
All right, Ms. Hutto, you're here in 26 CF 994, charged with possession of a controlled substance without a prescription. Third-degree felony, you understand that?
Judge, I'm going to enter a plea of not guilty on her behalf, 15 days pre-arraignment motions and trial by jury.
Just for your situational awareness, Mr. Williams, she also has 26 CF 1129 is set for arraignment in front of Judge Clark, 716. So I'm guessing they'll file a motion to transfer that case back up here.
Yes, sir.
I'm sorry, what was that? She's saying something I can't hear.
No, ma'am, we're not going, we'll have them track together, and if there's a plea agreement, it will cover both, but they're not going to be combined for trial. All right, Judge, has an information been filed on that one by any chance? If so,
No,
I'll go ahead and
oh, wait,
read it.
hold on. I'm sure no one has a copy of it, so. And I think she has to appear in front of, until it's technically transferred, it's not my case.
I understand, Judge.
So you'll see Judge Clark on the 16th, and then it'll probably get transferred back to me. That's not the case we're here for. So August 26th at 9 o'clock for your pretrial conference, Ms. Hutto.
Once it
All
gets
right.
up here, I'll have it on the same date,
So
okay?
Kaylee Costin. Ms. Costin is here in 26 CF 944, charged with retail theft over $750 or coordinating with others and contributing to delinquency or dependency of a minor.
Yes, sir.
Mr.
Judge,
Williams.
I'm going to enter a plea of not guilty on her behalf, 15 days pre-arraignment motions. We're working on trying to get this resolved, I think, ultimately for PTI, but I'm going to have an evaluation.
Okay,
Just to be safe.
all right.
Does the court show that the information is filed? Because I have it filed. in my-
Oh, yeah, okay.
That, she has one in her hand, so yeah.
Okay.
All right, we'll see you back on August 24th at 1 o'clock. Stay in touch with Mr. Williams. All right, Danielle Renee, starts with Krejci.
Tracy, I think is how she pronounces it. Judge, we got a phone call from her at my office a little while ago.
Okay,
She's just had some car issues and is running a bit late. If we can pass her to the end of the docket.
let's pass her and we'll call her back up.
Thank you, Judge.
All right, and Leckler, we already did this morning.
Yes, sir.
All right, Kevin Lloyd, we already did this morning, right?
Yes, sir.
Isaac McConnell. Let's make sure everybody turned their ring camera off. All right, this is Mr. McConnell, 26 CF 877, charged with battery by strangulation and false imprisonment.
Yes, sir. I'm going to enter a plea of not guilty on his behalf. Request 15 days pre-arraignment motions, trial by jury.
All right, Mr. McConnell, your next court date's going to be August 26th at 9 a.m. It's your pretrial conference date. We'll see you then.
Thank you, Judge.
All right, Jalen Meeks. All right, Mr. Meeks is here in 26 CF 1012, charged with defrauding to obtain property, vehicle theft, and unlawful use of a two-way communication device.
I'm going to be entering a plea of not guilty on his behalf, 15 days pre-arraignment motions, trial by jury. We're waiting to see if somebody else gets charged as well, and if so, we'll be filing a motion to withdraw.
Okay. All right, Mr. Meeks, it's going to be August 26th at 9 a.m. for your pretrial conference.
Thank you, Judge.
All right, Cody Miller. Is Cody Miller here?
Judge, I thought he was pled into drug court.
Cody Miller went
yesterday.
into drug court last night, Judge. I
Okay.
apologize.
So we can take that off our docket. Kendra Moore, we already did this morning, correct?
Yes, sir.
All right, Holly Nielsen. All right, Ms. Nielsen's present. She's here in 26 CF 880, charged with unlawful use of a two-way communication device and obstruction of justice, harassing a witness.
Yes, sir, Judge. I'm a pleader not guilty. Request trial by jury, 15 days for pre-arraignment motions. Hopefully, we can get this resolved with a plea.
August 26th, 9 a.m. for your pretrial conference, Ms. Nielsen. Mr. Williams will come out and talk to you. All right, Freanna Powell. Followed by Jerry Reynolds.
All right, can we bring her back later? Let me go over something we may, and talk with the state. We may have an offer here. Okay.
All right, we'll bring back Ms. Nielsen later. All right, Ms. Powell is present, 26 CF 945, charged with battery by a detained person, or not a person detained.
Your Honor, we had to file a conflict on her case.
Okay.
We also represent.
I see a motion to withdraw. Here's the order. All right, I just signed the order. All right, so Ms. Powell, what's going to happen is you're going to get appointed the Regional Office of Conflict Counsel. I'm going to enter a not guilty plea for you and put you on August 26th at 9 a.m. Mr. Kleins will come out and talk to you. He's going to be your lawyer. This is Jerry Reynolds. Do you not have one for him? All right, Mr. Reynolds, you're here in 26 CF 976, but we don't have an information filed. Status from the state? Initial charge of felony battery. It's a third-degree felony, so Mr. Mull, I'm assuming that's you?
Okay, Mr. Reynolds was the one. I spoke with the victim. She had already come in and filed a drop charge request in our office. I spoke to her yesterday in between the courts and was able to get a hold of her to talk to her. She's adamant she does want to have it no pros. So the state will announce today a no pros in case number 26 CF 976.
All right, Mr. Reynolds' case is dismissed. Thank you. Mark Robinson. All right, Mr. Robinson's here in 26 CF 990, charged with battery on a person detained.
Your Honor, this is also another one that we had to file a notice of conflict on.
Okay, I do see the order there. Signing that now. So what's going to happen, Mr. Robinson, is the public defender has to withdraw from your case. I'm going to appoint the Regional Office of Conflict Counsel. So Mr. Kleins is going to be your lawyer. So was there an information file? There was, and he's got a copy of it. It's the battery on a detainee, like I said. What I'll do is enter a not guilty plea for you, Mr. Robinson. I'll put you on August 26th at 1 p.m., I'm sorry, 9 a.m., and Mr. Kleins from RCC will come out and talk to you.
When is the court date, did he say?
Your Honor, what was the court date again?
Oh, I'm sorry, August 26th. I don't know if he has any other cases in my division or if there's going to be a motion to transfer. Just so you know, Mr. Robinson, looks like you've got several cases in Judge Stone's division already. They may end up moving to transfer this case down there, but I don't see that filed yet. So you may end up just in front of Judge Stone with a different lawyer.
I think they're VOPs.
Are they all VOP? You might be right, so that you might stay
Then
here
they
with
would
us.
all come up here.
Okay, so they might transfer your VOPs from Judge Stone's division up to me. All right, but as of now, it's August 26th at 9 o'clock, and your lawyer will come out and see you.
Mail that lady.
Quincy Roof. Thank you, sir. All right, Mr. Roof, you're here in 26 CF 946, charged with 2 counts of child neglect. Information has been handed to Mr. Roof.
Your Honor, in 26 CF 946, we're going to enter a not guilty plea and request trial by jury.
It's going to be August 26th at 9 o'clock for pretrial. Looks like we've already got a bond hearing set for 2 weeks.
That's
That's
correct.
July 9th at
9 a.m.
9 a.m.
Your Honor, could I be heard on that, please?
Sure.
I will not be available on the 9th because I'm in front of Judge Stone in trial. It's trial specially set.
Okay.
Can we?
Can someone cover a bond hearing for you?
Okay.
Looks like Ms. Basso just volunteered. Thank you, Ms. Basso.
Okay.
All right, July 9th at 9 o'clock for the bond hearing. All right, Kevin Rosen, also an inmate.
Mr. Mull?
All right, Mr. Rosen, you're here in 26 CF 1011, charged with driving while license suspended, third-degree felony.
No information.
Does the state have any information on Mr. Rosen?
I have a note in here
Okay, what does the note say?
to see if it's going to be able to be prosecuted as a felony or not. He does have 7 pages of DWLSR, 7 pages of a driver's record. I can't read it because it's turned sideways, and I've tried to look at it without printing it out, but
Did
it
you just hit
looks
that little
like
button that rotates it?
it does have it on there, but it's very tiny.
Can you hit the next button that says Zoom?
Well, the issue is I think he does have the priors. I just don't know whether they are, I don't know whether. Yeah, I need to look at it closer to see if the reasoning why he had the DWLSRs in the past was because of DUI or a HTO. I
Okay.
don't see any HTOs, but there are DUIs on there. But it looks to me like he had them already replaced by then, and that this is a medical issue for his commercial driver's license, as opposed to it being on a regular driver's license, that he didn't do the medical background and they suspended both licenses. But I can't really make all that out sitting here doing.
Okay, is there anything else holding Mr. Rosen? I just see $1,000 cash or professional bond.
Correct, Your Honor, and he cannot post that bond.
I mean, even as a misdemeanor with that kind of history, I think 1,000 would be reasonable, but you're free to set a bond motion. All right, let's bring back Mr. Rosen for 2 weeks, Mr. Mall. July 9th at 1:30 for a second arraignment hearing, but if nothing's filed by then, I'm not gonna entertain more arraignment hearings. My policy is after 2 arraignments, if you still haven't filed anything, I just take it off the docket. And I'm probably gonna give him and release him at that point, because you haven't filed anything, it'll certainly be more than enough days by then. Because he was arrested May 26th, so you're pushing up against 33 days as it is. But, Ms. Rivers, you've been appointed, so I'm sure you're tracking everything that we're talking about as well.
Yes, Your Honor.
All right, Mr. Rosen, unless I see something new, it's going to be 2 weeks, July 9th. Like I said, we can file a bond motion. There may be some concerns if they don't file information in time, but we'll see you back on that date. Kathleen Shaw.
This is the day.
Okay.
Yeah. Yep.
Is this Ms. Shaw? All right, thank you, Ms. Shaw. You just better hand in information in 26 CF 878, where you're charged with battery on a health service personnel, third-degree felony.
Yes, Your Honor. We're going to enter a not guilty plea and request trial by jury.
All right, Ms. Shaw, your next court date's going to be August 24th at 1 PM. Stay in touch with Ms. Rivers.
Okay. And I'm going to have her stay here with me for a few minutes, Your Honor.
I got papers. Wait, I got papers that I went and signed for the judge. I didn't get this until, remember I called your office, and then they told me to call. I wrote this up for,
Did you file it?
yeah, I went up to the court.
Just a little information, Ms.
No,
Rivers. It's a failure to appear from
They said they'd call me.
June 16th, and there's a $2,000 cash or professional bond on the warrant.
Is there any way you can have it where I can see her before? jail.
I got your phone in first, right here, ma'am.
Thank you.
Thank you.
Oh.
In reading this, Ms. Rivers, it sounds like those two cases are related. There's a DUI and it was at the hospital where there was the battery. So it might end up getting consolidated, but I don't know. All right, Matthew Sheets. Matthew Sheets is here in 26 CF 932. I'm going to hand in information, aggravated battery on someone over the age of 65 with great bodily harm, which is a first, sir, up here, which is a first-degree felony. Do you understand that, Mr. Sheets?
I do, Your Honor.
Okay. Can you afford an attorney to represent you in this case?
I do not wish to be represented by an attorney or public defender in this matter, Your Honor.
Okay. So you want to represent yourself?
I do, Your Honor. I've requested for a hearing as soon as possible.
All right, we'll put you on for, let's see. Let's put him on for July 9th. That's 2 weeks for the Ferretta hearing, 9 o'clock.
Your Honor, may I address the court?
Sure.
I, Matthew Sheets, formally and respectfully demand a speedy trial for the felony charge of aggravated battery on a person 65 years of age or older. I've already submitted 1 month ago a writ of demand for a speedy trial.
Well, just to make sure you understand, Mr. Sheets, that the new speedy trial rule, that your speedy trial time doesn't start till the information's been filed. Your demand was filed 5 days. Sir, listen to what I'm telling you instead of trying to show me paperwork. I understand that you filed it, but the time doesn't start until the information has been filed. Just want to make sure you understand. Information's been filed and given to you. I understand that you've asked for a speedy trial, and we'll address that.
Yes, Your Honor. As is my right, I also like to request an assistant.
And the other, an assistant?
Not an pardon me.
What are you reading from, Mr. Sheets?
I'm not reading.
Okay, well, I need you to tell me what you're asking for.
I wish to move forward, Your Honor. Don't disregard that. Let's just
Okay,
move forward.
so you're ready for trial?
I'm ready for trial, Your Honor.
Okay, well, we'll address your Ferretta hearing on July 9th.
Is there any way I'll be able to get any of my discovery and any of my information?
Well, you said you're ready for trial.
I don't have any, the state hasn't given me anything.
Have you asked for it?
This is my first court date.
Have you filed a notice of discovery under Florida Rule of Procedure 3.220?
Well, y'all did not appoint me an attorney.
You just told me you didn't want one.
Right, but as is my, I have a right to an attorney, and y'all didn't appoint me one on my first appearance.
Well, at first appearance, you refused to sign your paperwork and didn't ask for one. In fact, you said you wanted to be pro se according to the paperwork that I have.
Okay. Okay, thank you, Your Honor.
Okay, so they don't have to send you discovery until you request it in writing.
Yes, Your Honor.
Again, it's Rule of Procedure 3.220.
Yes, Your Honor.
I'll see you in 2 weeks for your Ferretta hearing.
Thank you very much, Your Honor.
Say again?
Thank you very much.
Plea of not guilty will be entered on his behalf. All right, Dakota Staines, did we handle?
We did Mr. Staines this morning.
Miss Shaw, did you put her on the 824 or the 826?
826, because she's currently incarcerated, but it'll probably end up being the 24th. All right, Christopher Wilson.
Your Honor, we filed a waiver of appearance.
Okay. 26
We're gonna
CF 992, did you file a plea of not guilty as well?
Yes, Your Honor, we're going to officially enter a not guilty plea and request trial by jury.
All right, so he'll be he's out of jail, right? Yes.
Yes, Your Honor.
8/24 at 1 o'clock. All right, Michael Zinneman. Oh. He's an out-of-state fugitive and he's not in the jail anymore.
It says that we filed it, but I don't see it in there, so I will make sure we get the no pros filed.
But you're announcing it at this time?
Yes, Your Honor.
All right, follow that up with your written all pros cases dismissed. And I think that's everyone. Are y'all ready? Go ahead.
I know it was originally on Miss Staten. It was on originally, I think Mr. Kleins had moved it or whatever.
Which one?
Diane Staten, 26 CF 895. I'm not sure it was originally on here. I wanted to let the court know, because we didn't file an information last time, and we're announcing a no pros today on that case. I filed it.
I see that it was filed today.
Yes, we've been trying to reach the victim, and we have been unable.
Just to make sure, is Diane Staten here? Staton?
Thought she was in jail.
Is she in jail?
I've been getting letters from her from jail.
Let me take a quick look. She's in jail. It says hold. I don't know the basis of the hold. But this case is dismissed if we can make sure to send over a copy of the court minutes to the jail. All right, sir, come on up. Can you announce your case again?
Mr. Ralph Conklin, third, Your Honor, case number 26CF001003.
All right. Adjudication, 36 months probation.
I did get the information.
On Conklin?
Yes.
All right, perfect. Do y'all have a score sheet, Mr. Mall? All right. I'm assuming he doesn't score? Okay. All right. Mr. Conklin, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. You're here in 26 CF 1003. It's a driveway license suspended as a habitual traffic offender, third-degree felony, punishable by up to 5 years in state prison and a $5,000 fine. Do you understand that?
Yes, Your Honor.
All right. I've got a plea and sentencing agreement here that calls for you to plea as charged. I mean, adjudication of guilt. That's a felony conviction. Court costs of, what's the court?
Sorry, 548.
$548 on the court costs. You'll be sentenced to 36 months of probation. You're eligible for early termination, but I'm not ordering it automatically because that's not what it indicates here. But that's would be at halfway upon successful completion of the conditions. Make your best efforts to obtain a valid driver's license. We'll be transferring your probation to Pinellas County. And they'll give you the reporting instructions here. You'll talk to Mr. Barry from probation before you finish up. All right, is that your understanding of the agreement?
Yes, Your Honor.
All right, and did you have enough time to go over this agreement with your lawyer?
I did.
And did you understand and sign the agreement?
I did.
Are you satisfied with your lawyer's advice and representation in this case?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I've read to you? And do you understand by entering a plea there won't be a trial of any kind? And do you understand you're giving up your trial rights, which are on page 2 of the agreement that you stated you understood and signed?
I do.
Okay, and do you understand you're waiving any potential defenses that you may have?
I do.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? And finally, do you understand this is a driveway license suspended as HTO? This may trigger a new 5-year suspension for habitual traffic offender. Do you understand that? Okay. Based on those things, Mr. Conklin, what is your plea as charged to the driveway license suspended?
No contest.
I'll accept your no contest plea, adjudicate you guilty, $548 in court costs, 36 months probation. You're eligible for early term at halfway. Upon successful completion of your conditions, make your best efforts to obtain a valid driver's license. I don't have any objection in transferring your probation to Pinellas County. You're going to meet with probation, who's sitting there behind you after that, or do you want to do fingerprints first? All right, let's do prints first. So you'll come up here, do the fingerprints, then you'll go back to Mr. Berry to talk to him about your probation reporting instructions. Then you have 30 days to appeal the judgment and sentence of the court. Good luck to you, sir. This is the guidelines, I believe, from Mr. Conklin. It looks like he scored 9.7 points, so this is clearly a guideline sentence. And I'm signing that now. All right, thank you, sir.
Thank you, Your Honor.
Have a good day.
Yeah, it's just so the court's aware, Ms. Creasy's here. I have spoken.
Who? Oh, Grease, okay, the one who had
Yes,
the
sir. And then there's another
car trouble.
individual here that I think we may have called earlier and need to get him in front of the court.
Okay. You want to handle Creasy?
Yes, sir.
She here
Yes, sir. She is.
in the room?
Back.
Ms.
Creasy,
Creasy,
come on
come on up. This is 26 CF 834, and information has been filed charging with shooting at or into or within an occupied vehicle, second-degree felony, aggravated assault by threat with a deadly weapon, third-degree felony, discharging a firearm, first-degree misdemeanor, and using a firearm while under the influence, second-degree misdemeanor.
Yes, sir. I'm going to enter a plea of not guilty on her behalf, request 15 days for any pre-arraignment motions and trial by jury. Me an email so I've got yours in the system, okay? And I'll send you that link.
All right, Ms. Creasy, it's going to be August 24th at 1 o'clock. Stay in touch with Mr. Williams. We'll see you back on that date.
Thank you.
Thank you, Judge. Now, sir, in the back, come on up.
Who is this?
What's your name, sir? Scott Hampson?
Hampson?
Hampton?
Hampton? I don't
And
have
I'm
it.
not showing him on the docket. We did have,
Well, why don't y'all look into that and see if he's in the right place?
yes, sir.
All right. Anyone else that was supposed to be on the 1:30 arraignment docket? All right, your name, sir? Come on up. I can't hear you. Livingston? I don't see you either.
Judge, I think Mr. Livingston, we filed a, hang on a second.
It's a written plea of not guilty filed.
A written plea of not guilty was filed by,
And Mr. Williams.
by Jay Williams?
Yes.
Okay. I just want to know what that, so I can put it on the right court date. All right, so they filed a written plea of not guilty on your behalf, Mr. Livingston. Mr. Williams is your lawyer. It's going to be August 24th at 1 o'clock for your pretrial conference. Just make sure you stay in touch with him. All right, anyone else that was supposed to be on the 1:30 docket? All right, 2 o'clock. I've got a lot of attorneys here. I've got no list because no one gave you all one to sign up. Anyone have anything quick? I'm going to try to get the private lawyers out of here first, since you have the motion to suppress too, Mr. Maddox.
That's fine. We should be quick as well, Judge.
Okay.
I'm going to jump since you
Okay, Ms. Merrifield, this is Fleming.
Yes, sir. And it's 25 CF 2322, Bernie Merrifield on behalf of Nigel Fleming. We are here today on the state's motion to revoke bond, and Judge, I am going to be asking for a continuance.
Okay.
So when we were here last.
I hadn't seen that. I see that you filed it now, but I hadn't seen that when I looked at it.
Yes, sir. When we were here last on the 28th, the state was instructed to file a motion because we just had the affidavit of violation from pretrial, and the state did so, and I did receive that timely.
And just to make sure it's clear for as far as the record is, I read that affidavit. I wasn't quite sure what it really was telling me, so I said if it was going to be pursued, it would have to be by a motion to revoke bond.
Yes, sir.
But just to make it clear, I didn't tell the state they had to do that. I just said that's what, if that happens, then we'll set it for a hearing.
So we had that hearing on 5/28. In that hearing, found out that there was some information that we were not privy to, filed the appropriate motion and order. I actually filed that on 5/29. I didn't receive, and Ms. Leone responded that she didn't object. And in the meantime, I received her motion to revoke bond. I didn't receive a response, so I started following up, Judge. I think it may have fallen through the cracks. The long and short of it is you signed the order at 10:30 this morning. I finally.
Someone reached out to my office, and I think I've talked about this a couple of times this week on these CPT, DCF records.
Yes, sir.
It's not just that I'm gonna know that the state agrees to the issue, but they agree to the language in that order.
Yes, sir, understood.
And once I saw that and I was told about it, I signed it while I was still on the bench this morning.
Yes, sir. I received the information, quite a bit, plus a video, just a few minutes before I had to get on the road and head here. I was only
Okay.
able to review a portion of it, so I am going to need an opportunity so that I can be prepared to defend that, because it looks like most of the crux, now that the state's filed a motion, and I know what her contentions are, a lot of that is going to be related to some information in that CPT
Okay.
information.
All right, Ms. Leone, objection to the continuance?
No, Your Honor, I discussed that with Ms. Merrifield. I just asked that it be set sometime in August.
August? Okay.
I'm open to whatever date the court has.
I think it'd be August 6th.
Any date after the 6th, Your Honor?
27th?
Is it okay for you?
I'll make it work. The 27th sounds good to me.
That's fine, Your Honor. 2 p.m.?
Yes, 2 p.m.
Okay, thank you.
August 27th.
Thank you,
Okay,
Judge.
thank
All
you,
right,
Judge.
thank you. And I apologize for not getting that done earlier, but obviously, you know where I've been all week, and I want
Yes,
to make
sir.
sure, just, if you're not getting that in there, there is the agreement on the language, just contact Katie directly and tell her it's ready to go, and she basically green flags it in my
Yes, sir.
system, so I know I can sign it because it's done.
Thank you, Judge.
All right, thank you. All right, Mr. Harper,
Samuel Mosley, 16 CF 2013.
my understanding he's not here, right?
Your Honor, yeah, he's still in DOC. He was transferred back there. We just need a date. Hopefully, we
I
can
tried to
get
give you
this-
one today.
If we can give a date 2 months from now, in
Okay.
that I have a couple of doctors that will need to be subpoenaed.
Okay.
And an issue from before is that they've been unable to clear their schedule. I'm hoping that 2 months is sufficient. And I would defer to Ms. Bossa. We have similar calendars, but I know you have additional court dates. As to her availability, I will be available on whatever date that is, Judge.
My only question will be then if it's Mr. McKinney available, but I can verify that while we're still here. If the court wishes to give us a date, I'll just reach out, since that'll be the witness that I need. And he also has court schedule. I should be able to also check the dockets.
You said 2 months?
Yes, Your Honor.
That same date I just mentioned to someone else, August 27th?
That's fine.
Does that work?
Looks like it should work for the state. I'll just verify with Mr. McKinney. I don't see anything on a Judge Stone docket though, so it should probably be okay.
I think that would be his trial week, so I think both he and Judge Clark have their trial weeks kind of the opposite of mine. They're the 1st and 4th, I'm the 2nd and 3rd.
Actually, Judge Clark's, Your Honor.
Yes,
Well,
Judge.
so
I mean,
Judge
that-
Stone
that's what
probably,
the date is.
Judge Stone probably has a nice civil trial week that week, so. All right.
That works, Judge. Thank you.
All right, August 27th at 2 o'clock for the Mosley hearing. If there's anything y'all want me to review ahead of time, please give me some time on it and send it in advance. That way I can prepare, and obviously the, excuse me, the staff attorney is involved in it too, so I want to make sure we get to be as prepared as possible for it. I know this case has been out there for quite some time.
Thank you, Judge.
All right, thank you. All right, Mr., he's, have you had a chance to meet with Mr. Ford yet?
No, sir.
Do we have Mr. Ford back there?
Yes, sir. The bailiff told me he wanted to talk to me, but I was waiting to see what was going on.
Well, the issue was I tried to appoint you, and for some reason, you never got notice of that. I think because they didn't give me a written order, but we announced it in court. And I think you ran into Mr. Klein's. He told you about it at the jail the other day. He was pretty adamant about meetings with his lawyer, and since I knew you were going to be here anyway before, he's here. All right. Okay, why don't you do that, and I'll handle the other ones, and you'll be first up as soon as you walk in the door, Mr. Cobb.
Yes, sir.
Ms. Dudley?
Adam Sheets.
It's a bond hearing, right?
Yes, sir.
Sorry, I think I left my docket upstairs during the lunch hour. No, I mean, I can see everybody, I just can't see my notes, but I didn't have anything extensive on most of the people. I remember what they all are. All right, Adam Sheets is here in 25 CF 2249. It's a motion to reduce or set bond, excuse me.
It should be motion to reduce also.
It should reduce
Yes,
because he
sir.
already has bond. Okay, all right. Go ahead, Ms. Dudley.
Yeah, Mr. Sheets is currently incarcerated on a $31,500 bond. He cannot make that bond. I do understand that he was out on bond and got a new traffic charge, and then the court set this bond on the charges. The issue is, at this point, the evidence that
This
I
was
have.
the operating a motorcycle without endorsement was
Yes,
the
sir.
reason?
Yes, sir. And the court ended up setting the $31,500 bond before I got on the case. Your Honor, I'm asking that his bond be reduced so they can make bond. I've went through all the discovery, every body camera, everything I've been provided. And most of the discovery, which the state's going to look into, I guess. I think I'm the second attorney on the case. This has been since November. So when I get the discovery, they're just half of the some of the supplements say draft on top. Some of the supplements are just a little narrative and it's empty.
So I have to say that this was the case I was thinking of this morning when I talked about there was a concern as to whether it was actually fentanyl or something else. I was like, I know I read something about this issue, but I couldn't remember which case it was.
Yes,
And I
sir.
did want to confuse it with someone else, but this is the one I was referring to.
We
I'm
don't
sorry.
have-
Go ahead, Ms. Dudley.
We don't have any, from what I can tell, I haven't received any lab reports. Most of the narratives, actually all of the narratives, unless they talk about like the cell phones being taken or they had to breach the house, none of the narratives talk about the actual service of the search warrant and outside of the arrest report or affidavit of complaint. The affidavit of complaint talks about less than 1 gram of meth and plastic bags found inside of a room that say belonged to the defendant, and then less than 1 gram of meth found in the wallet of the co-defendant. She's already entered a plea. There's nothing even mentioned in the arrest report about fentanyl. I can't figure out where the fentanyl's found. I watched the body cameras. Yeah, he's charged with possession with intent to sell fentanyl within 1,000 feet, which makes it obviously a higher crime. And also, that's the count that has $25,000 cash professional bond on.
Okay.
Your Honor, he's been sitting in jail. I was going to try to file a motion, but obviously my concern is I don't really have any information for the facts of the case outside of the affidavit of complaint, because to show any of the other charges, the report states that he says he was asleep. When they did a search warrant, the co-defendant said he was asleep, so that took care of the last count. So it's hard to figure out what to do with the case when we're missing the supplements and narratives about the actual search warrant and the search warrant itself. I would ask that the bond be reduced to something that he can make. He's not a flight risk, amenable to any conditions the court deems appropriate. But I felt like this case it was continued yesterday because I don't have the information in the case and I can't file a motion because I know once I file it, there's going to be information that starts flowing saying, oh, that's not what happened, that's not what occurred, when all I have is a probable cause statement at this point. As far as he's charged with the crimes from November 14th. Most of the documents deal with all the information they got beforehand, but not with the date that he's actually charged with in this case. So we'd ask that the bond be reduced in this case, Your Honor.
All right. Mr. Sheik?
Your Honor, a lot of these concerns were relayed to me very recently, and the state is taking active measures to attempt to allay all the concerns and provide every document that we can get. But our general assessment is that we feel that the bond is appropriate in this particular case.
Okay, do you have anything that seems to show or confirm that this is fentanyl that's being discussed? Because everything in the arrest report I also read says methamphetamine. Not that one is just fine, but it's a little less of a problem than the other.
Yes, Your Honor. I am unaware of anything that directly identifies fentanyl.
And why was it filed as that? Because even when I'm looking at the affidavit of complaint or arrest report, count 1 just says deliver controlled substance schedule 1. Doesn't even list what it is. And then in that same report, it only talks about methamphetamine. Did a lab report come back as fentanyl? I mean,
I
I've seen
do
them
not
kind of
have a-
cross wires
No,
on that
I-
We don't
before.
have a lab report.
I am unsure why, honestly. Some, like I said, this was recently brought to my attention and I've been in court pretty much every day. So I have not been able to research it as in-depth as I'd like to figure out if there's something I'm missing. But all candor, I don't know where the fentanyl comes from, Your Honor. And I couldn't answer to why it was filed that way at this time. And no, we do not have any, I do not have any drug reports about fentanyl.
All right, any other further argument?
No.
No, Your Honor.
All right, what I'm going to do is, for the most part, set the bonds back to where they were before the motorcycle endorsement issue. So I believe in that case, it was $10,000 on the distribution issue. Again, I see some problems here. I was hoping to maybe see them fixed, but I know this was just set yesterday, but I'm sure y'all have discussed this. $1,500 on the possession of controlled substance, ROR on the paraphernalia, and then $3,000 on the obstruction. And I understand your argument about that, Ms. Dudley, about what was going on, but unless we're going to put on full-scale evidence, I'm just going to make it what it is. So that's what his original bond was, so it's $14,500 cash or professional, pretrial services, report to them by phone once per week, in person once per month. Do not possess or use any controlled substances or illegal drugs unless you have a written prescription for any controlled substance. All right. Anything else the state is asking for?
No, Your Honor.
All right. Anything else for you, Ms. Dudley?
No, Your Honor.
All right. And we already set it for what, August 26th?
Yes, sir.
Okay. And obviously, if it's released, you can do it on the 24th.
That's all I have, Your Honor.
All right, thank you.
you.
Mr. Hardy, you got Miss Anderson, I believe? Oh. That looked like a Pat Leo to me.
Anderson is present and approaching. Your Honor, we're here asking the court to modify Ms. Anderson's community control back to standard probation. Her probation was modified in September of '25. She had violated for a case in Hillsborough County. She went to trial on that case and was found not guilty.
I think it was modified again after that, right?
Yes, it was modified again in January to allow her to travel, to do her time sharing here. Your Honor, she's completed all her requirements.
Okay.
What we're asking to do is convert this back to probation. Ms. Anderson's job, she oversees medical billing. There's 18 locations in 4 states.
And I reviewed it in your motion.
Yeah, and as it currently sits, she just can't do it.
All right, State.
Your Honor, the state would request that we call the victim of this particular case to...
Is he here?
Yes, he is.
Oh,
Mr. Anderson.
Per usual, whoever I'm looking for is behind someone. All right, Mr. Anderson, you want to come on up? Do you have an issue with him being at the podium?
that's fine.
I know this has been a very contentious situation between y'all. I didn't know if there was going to be a concern. All right, Mr. Anderson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, and your name, sir?
My name is Carl Anderson.
Okay, go ahead with your questions, Mr.
Your Honor, I believe he just had a...
You just want a statement, okay. Go ahead, Mr. Anderson. Tell me what obviously, you know I'm familiar with the situation since way back at the initial injunction. I don't know what's going on with the current family law situation. I know we discussed it a little bit at the last
I can tell you, Your Honor, we're set
situation.
for a final hearing on July 12th.
July 12th. Oh, that's coming up
13th.
quick. Okay,
13th, I'm sorry.
13th, okay.
I could read my
Go ahead.
Okay. Your Honor, I respectfully submit this statement regarding Ms. Sheena Anderson. Ms. Sheena Anderson's request to modify her sentence from the community control to standard probation. As a victim in this case, I respectfully ask the court to deny her request. The issue before the court is not whether community control is inconvenient. The issue is whether Ms. Anderson had demonstrated sustained compliance with court orders, accountability for her actions, and a sufficient basis to justify reducing her supervision. Based on my observations and the ongoing litigation between the parties, I do not believe she has. Throughout her request, Ms. Anderson makes numerous claims regarding hardship employment and parenting responsibilities. However, she has not provided the court with evidence supporting those claims. She states that community control interferes with her employment and limits her ability to perform her job, yet she has not submitted a letter from her employer, proof of employment, documentation of travel requirements, disciplinary action, or any evidence demonstrating that community control has negatively impacted her job. In fact, Ms. Anderson obtained this position while she was already on community control. If community control was prevented her from performing her duties, it is difficult to understand how she would have been hired for that position in the first place. Even in our ongoing family law case, she has never provided proof of employment despite numerous opportunities to do so. Her request is based upon unsupported statements rather than evidence. Likewise, Ms. Anderson claims community control interferes with the exercise and time sharing. That claim is also unsupported. This court has already modified her condition to allow travel to Okaloosa County every other week for time sharing, and she is currently able to exercise that parenting time under existing circumstances. Most importantly, Ms. Anderson has demonstrated a continuing pattern of violating court orders. This pattern did not end when she was placed on community control. As a condition of her supervision, Ms. Anderson is required to comply with the final judgment of injunction and the related emergency order governing our minor child. Despite those requirements, she has continued violating those court orders. In fact, during a recent hearing before Judge Gonteric on April 28, 2026, she was specifically instructed to comply with both orders. Despite receiving that direct instruction from the court, the violations have continued, and the motion of contempt is currently pending in our family law case. Community control exists to provide accountability. Reducing supervision while this pattern of noncompliance continues would undermine the very purpose for which community control was imposed. I am also concerned because the behavior that resulted in Mrs. Anderson being placed in community control has not stopped. Rather than accepting accountability, she continues engaging in conduct that I believe reflects the same pattern of harassment and intimidation. Regarding the Hillsborough County incident referenced in her request, I personally witnessed Ms. Anderson near my vehicle, recording it before she called another individual over. That individual ultimately damaged my vehicle, was criminally prosecuted, and accepted responsibility and paid restitution. Although Ms. Anderson emphasizes dismissal of her charges, that is not my concern. My concern is that the incident demonstrated the same behavior that resulted in community control being imposed in the first place, and the reason why she was violated was because she was out of the county without permission that night. As a victim in this case, I am deeply concerned that reducing Ms. Anderson's supervision will provide her with greater opportunity to continue victimizing me. Unfortunately, that pattern has continued through other means. Rather than harassing me directly, Ms. Anderson has increasingly used the legal system and third parties to continue that behavior. She has filed numerous injunctions, one in Hillsborough County and I believe 4 to 5 in this county alone, against me, all of which were denied. She has repeatedly used the court filings and legal proceedings to continue contact without legal justification. Her conduct has also extended beyond me personally. She has repeatedly contacted, harassed our son's daycare regarding our matters unrelated to our child's welfare, contacted individuals who provide child care
Sorry,
for me.
Mr. Anderson, can you just focus on the community control issue? And I'm not trying to hear your final hearing in your divorce case right now. I told you I'm familiar with the situation. You know that. You know I'm the one that granted the injunction in the first place. So let's focus on how community control actually is the issue here or not, and not just tell me every bad thing you think she's ever done. Thank you.
Yes, sir. Yeah, like I just to wrap it up.
Allegedly has done according to you.
Well, I have videos, I have
That-
everything.
Okay, and those will be great for your family law hearing, but this is not family law court. The sole issue that I'm trying to decide is, does she need to remain on community control or go back onto regular probation?
Yes,
So let's focus on that issue.
Yes, sir.
Go ahead.
Throughout her request, Ms. Anderson asked the courts to reduce her supervision because she believes community control has become burdensome. However, she has not shown that she has earned that reduction. Instead, the evidence demonstrates ongoing pattern of violating court orders, continued behavior towards the victim, and making unsupported claims without documentation. As a victim, I remain concerned that reducing Ms. Anderson's supervision will remove an important level of accountability and increase the opportunity for this behavior to continue. Community control was imposed for a reason. Based upon her continued pattern of conduct, I respectfully believe that reason still exists today.
All right, I know she's not being supervised here in Okaloosa County, but Mr. Barry, do y'all have any information or any sort of reports from, is it Hillsborough? I just remember it's the Tampa area, Pasco.
Your Honor, they have not submitted any reports to us saying that she's been in violation of.
Okay, all right. Anything else, Mr. Anderson?
No, sir.
Does anyone have any questions for Mr. Anderson based on his statement?
Not from the state, Your Honor.
All right, you can take your seat, Mr. Anderson. Thank you.
Sir, thank you.
All right. Any further argument from you, Mr. Hardy?
Briefly, Your Honor.
Okay. And Mr. Sheik, you'll get your opportunity. I just want to make sure everyone has a chance.
Look, there's still a no contact either way. It doesn't change anything from Mr. Anderson's perspective.
Correct me if, because I may be wrong, because I haven't been in the family law case for a while, but the contact, they're allowed to have contact, but through talking parents.
About the child only.
I think last time I actually made sure to bring that up because throughout my time in the family law arena, it was very often that even the slightest discussion away from something child-related can end up in a violation. And there hasn't been a violation up to this point. All right, Mr. Sheik.
Your Honor, I think the victim statements speak for themselves, and you additionally are very familiar with this case, so.
Well, I'm familiar with who it was at the time.
Yeah, but.
What I don't want to turn this into is the family law case.
Yes, Your Honor.
Thankfully, we're to the end of, almost.
All right, go ahead, Mr. Sheik. I'm sorry to
But
interrupt you.
that's it, Your Honor. The state would oppose based on the victim statements.
Well, in reviewing this, two things. Number one, she pled to the violation of probation because of the Hillsborough case, which ultimately she was acquitted on. So it's not that I can go back and change anything, but I certainly can take that into consideration. Obviously, there's a lesser standard of proof in a violation of probation hearing than there is in a criminal jury trial. But the way I look at it is that she spent 9 months on community control and hasn't had a violation. I've asked probation. They haven't received anything from Pasco County since. I mean, I understand, Mr. Anderson, your concerns. I think your concerns are mainly related to the family law outstanding issues. You've got a final hearing coming up. I don't see how community control is changing anything. There's still a no contact, Mr. Anderson. It's my turn now. That community control is not the issue. What happens in the family law case is what it is. I've already specifically, based on a previous motion back in January, allowed for her to travel. I think there was some discussion with probation here on how that could be done because there was concerns about her being here half the time and being supervised over there, and Mr. Berry had actually brought it up, and I can supervise that issue here, so she's been supervised somewhat here when she's come up. Is that right, Mr. Berry?
She's been visiting in the south end of the county.
Oh, so it's the south end.
Down there.
I remember that coming up because she said she was staying in Fort Walton, and so it wasn't going to be you specifically, Mr. Berry. No, it jogged my memory. But at some point, I think she's done everything she has to do as far as what the criminal court is concerned with. So I am going to grant the motion to make it regular supervision. Ms. Anderson, you just need to talk to Mr. Berry before you leave here today so he can tell you what you need to do next. And obviously, there's going to be some communication with Pasco to make sure that's done. Maybe I shouldn't go this far because I know y'all have a hearing coming up, but I think I've said this numerous times, not only in your case, but virtually every family law case I dealt with involving children. Do your best to put your animosity towards each other to the side and raise your child. I'm trying to remember his name, Cairo?
Cairo.
Okay. To the best of your abilities, take advantage of your time with your child and worry more about that than what the other person is doing, as long as you're not doing anything that's a mental or physical or emotional injury to the child. But, and because a lot of these things that I've seen during the course of these many cases has been parental animosity that can potentially affect the well-being of a child, and we should never do that to our children. I'm not saying one side or the other or both. I'm just saying that Mr. Hardy's probably heard some version of that speech from me about 100 times back when I was in the family law division, but I think it's always best to hear it. Thank you all.
Thank you, Your Honor.
Have a good day. Mr. Cobb? Do we have, were we bringing Mr. Ford out?
Ford, I didn't know if you wanted to do that or.
Yeah, let's get that. I had a chance to meet with him.
Okay. This is Kelvin Ford. He's got two cases, 24 CF 765 and 25 CF 2124. Mr. Cobb, you were appointed. I know that you just had a chance to meet him now.
I wasn't aware about the 2124 case. I was aware of the VOP case, but I did have a chance to meet with him. And I do see that I was appointed in the substantive law case as well. But I met with him.
You have the wrong number. Okay. I think 2124 is the new case.
Yeah, the new case.
25 CF 2124.
And then the 766 is just tracking along with the new case because it's a VOP.
I think it's 765, 24 CF 765.
765.
So I know you're new to it. I just wanted to, because I knew you were going to be here this afternoon for your other case. Mr. Ford obviously expressed some concern, the fact that he hadn't got new counsel, even though I appointed you. And again, I know that's not your fault, Mr. Cobb, is we just didn't have a written order go out to you. It was just in the clerk's minutes. But have y'all had a chance to speak? Is there anything that needs to be addressed today?
We have had a chance to speak, and he told me what he would like for the state to do to resolve both cases.
Okay.
I had a brief moment to speak with Mr. Moll about that. I will reach out to Mr. Moll this afternoon and tomorrow and even the weekend to try to see if there's a way we can resolve it. He doesn't want a continuance. He's adamant about that. The problem is I will be out of town on Monday. He wanted me to bring it back on Monday to see if we could possibly enter a plea. And so if I do work out some type of plea arrangement between now and then, I'll ask somebody to cover for me and do a plea if we get it worked out.
Okay.
He does want me to continue anything.
All right. Well, then are we setting the case for trial, Mr. Ford? Or have you all discussed that? I just asked you a question. You
Yes,
don't have
sir.
to raise your hand.
Like I said yesterday, I know there are extenuating circumstances involved in these matters, Your Honor, but
I want to know why we can't dispose of this matter today. I even spoke with Mr. Cobbs, and I let him know that I'd be even willing to take a reinstatement with a lesser included of a simple battery and a simple assault with a 3-year suspended sentence just to resolve this matter today.
I don't do suspended sentences,
Yes,
to be
sir.
honest. I don't think the reason and justification for them doesn't make sense to me.
Yes, sir.
All it does is limit the court's authority to do something that it doesn't require the court to actually give the suspended sentence. What is the current plea offer? Do you even know, Mr. Cobb? And sorry, I've said it in a way like you should know.
DOC guidelines, that's what he told me, that's what Scott Klein's told me when I met him.
Is it,
It's his case. It's Josh's case.
is Josh's case?
The VOP's,
Oh, okay.
yeah. The new law, yeah. But the last offer that I had seen.
I'm sure it
was-
says Marshall Mull on my system. That Mr. Mull did a notice of appearance back on May 8th in the 765 case. And in the 25 case, I'm also showing Mr. Mull as the attorney of record.
We will verify that, but the last I had, the offer that was given was a 10-year offer, Your Honor. From Mr. Sprouse when he had it before.
Okay. So, Mr. Ford, so the answer to your question is why we can't resolve it today is because their offer at this point is 10 years in the Department of Corrections. I know you don't agree with that. However, there's two things that can be done. We can continue the case, we can set it for an earlier date, or we can set you for trial, but knowing that your lawyer hasn't even seen an arrest report, let alone complete discovery. Go ahead.
Yes, sir, I understand. When I came to court on February 25th, my first court date, I demanded upon a speedy trial at the podium, Your Honor, where I was put off on a calendar call to come back March 2nd. Scott Klein's was the one that put in for a continuance. I did not want no continuance, so the day that I demanded upon a speedy trial,
But you were there.
I didn't ask for no continuance. I demanded upon a speedy trial on the 25th of February when I came back on March 2nd for a calendar call, sir.
All right, did you file a demand for speedy trial?
I did it in open court on the 25th of February.
Did you file for a paperwork of a demand for speedy trial?
On the 25th of February, I verbally did it at court.
I'm going to ask you the question the third time. I hope I get an answer to my actual question. Did you file any paperwork demanding a speedy trial?
Sir, I don't know if the represent, I didn't.
I'm going
have
to take that as a
representation.
no then,
No,
Mr.
sir.
Ford. I've asked you the same question 3 different times, and you're trying to give me a different answer every single time. An answer different to the question I actually asked you. All right. Rule 3.191, paragraph B. Speedy trial upon demand, except as otherwise provided by this rule, and subject to the limitations imposed under subdivisions E and G, every person charged with a crime by indictment or information shall have the right to demand a trial within 60 days. Here's the important part. By filing with the court a separate pleading entitled Demand for Speedy Trial and serving a copy on the prosecuting authority. So I'm going to ask you for the 4th time, Mr. Ford. Have you or any of your lawyers ever filed a written demand for speedy trial?
No, sir, because I have not had appropriate representation.
Okay, so what would you like to do today?
I would like to dispose of this matter, Your Honor.
Your choices are take their plea offer or plead straight up to the court or set your case for trial.
I would be ready to set for trial, Your Honor.
Okay, despite the fact that you've only just met your lawyer 10 minutes ago and he hasn't seen your case. Is that what you're asking? That's what you're wanting to do?
Can you say again, sir?
You want to set your case for trial despite the fact you just met your lawyer and he hasn't seen your case file yet?
I'm not willing to take no continuance and just keep being deprived of my liberty and my life, sir. I have kids out there. I've done lost my home and everything I own, sir. I don't understand that. I have rights as a citizen.
Judge, what are your trial dates for this cycle?
July 13th. I just also want to make sure you understand, Mr. Ford, because maybe Mr. Cobb's not familiar enough with your situation yet, but one of your cases is a violation of probation, right?
Due to a new law violation, but I have not been found guilty of new charge yet, sir. This charge.
Mr. Ford, here's the thing. I understand you want to argue with me, but I'm asking you simple questions.
Yes, sir.
And every time I ask you a question, you give me an answer that's not related to the question I've asked you. You have a violation of probation, right?
Yes, sir.
Okay, so if we set your case for trial, say you go to trial on July 13th and are acquitted, you understand you're still being held on no bond under VOP?
Yes, sir.
Mr. Cobb, what would you like to do?
I'd like for the state to set the VOP here.
We'll request to go ahead and set the VOP first.
Okay.
We'll try that, and then we'll try the new law violation.
All right, so what they're saying is they're going to set your violation of probation hearing now, and then they'll go forward with your trial.
I object to that, Your Honor, because I have not been found guilty of no new law violation yet, sir. That was the only condition.
They can go forward with your violation of probation before a trial on your new law violation, Mr. Ford.
And I'd be more than willing to meet with him next week and explain this all to him. They can still go forward with it, just like the judge said. All they have to do is prove the new law violation by a preponderance of the evidence, and that's something I can come talk to you next week about it and explain it to you.
Okay.
So they can still go forward with the VOP first. Nothing.
Again, I don't mind coming back and addressing it on Monday. Unfortunately, your lawyer's not going to be in town. Do y'all want to discuss it some more before you make any further decisions? Or I can set you for trial.
I understand that, Your Honor. I don't, it's just keep getting continued for 30 days, 60 days when I'm just sitting in jail for something that I didn't do, Your Honor. It just, that's not right. I don't mind for coming back Monday so I can have time to speak to him.
You're
but-
in jail
Yes,
because
sir.
you have no bond on your violation of probation, because a judge, probably not me, but found that there's probable cause to believe that you committed a new law violation. That's why you're in jail. The new case is not what's keeping you in here.
Yes,
It's
sir.
the violation of probation. I would guess you have a bond on the actual new case, right?
Yes, sir.
So it's the VOP that's actually keeping you in jail right now.
Yes, sir.
I just want to make sure you understand these things.
Yes, sir.
How would y'all like to proceed?
Guess we leave it on the trial docket, Judge, unless the state chooses to do the VOP first. I can't keep them from doing that if they want to try the VOP first.
We absolutely are going to try the VOP first.
All right, can you do that on July 9th?
I can do it on July 9th.
And Judge, just to make it clear, I believe there was some confusion initially, and that there are two people named Ford. Mr. Sheik has one. I have this particular Mr. Ford. His
Okay.
current offer right now that he has is 30, it's a score sheet offer. He scores. He scores 78.9 points. He has 38.175 DOC minimum sentence or guideline sentence for this case. And that's all we're seeking is just guidelines.
So the lowest permissible sentence is 35 months?
38.175.
Yes, Mr. Ford.
Excuse me, Your Honor. If I was to accept the offer of counter offer of 30 months with credit for all time served, would that be something we could negotiate?
That has nothing to do with me. You all can negotiate it all you want.
I'd be
but
able to, I just need time.
Mr. Cobb.
I understand that,
Mr.
but I
Cobb.
can't, I'm not getting to be a part of the negotiation. So y'all can go talk about it, which is what I just suggested. But I'm not going to be I can get invited into the negotiation. I don't have to walk through the door.
I wouldn't invite you.
I'm not coming in, so.
I took the 35 months. Is that going to count the time determined? Is from the time that I had everything?
Judge, why don't I take care of Ricardo Bryan?
Go back and
Get up
talk to
with
Mr.
whoever
Ford.
I'm supposed to deal with her there, and I'll see. And if not, we'll just leave it on the docket for Monday, and I can get coverage for that.
Can I ask you this, Mr. Cobb? I don't want to intrude upon whatever reason you're out of town, but is it something you could do as Zoom?
Yeah, I'm going down to help my dad, so I can do it via Zoom.
Okay. However y'all want to handle it, but I need to set court dates before we end it for today.
Just to let the court and defense know ahead of time, I don't, but it doesn't matter to me if you want to set it for 7/9, 6/29, 7/9, and 7/30 for the actual VOP evidentiary. We could still get him on the next docket. I don't know what he's wanting or what.
I agree with Mr. Mole. Let's set those dates, Judge, get them in stone. I'll talk. And if I can work this out quickly, I will, but I can't stick around until 4:30 trying to figure it out because I gotta.
I'd be
I
willing to
understand.
take the guidelines as soon as if I get all my credit for time served with running attorneys.
All right, I'll talk to him today. I'll talk to him about it. You're gonna have to go sit for a minute back there, okay?
Yes, sir. I don't mind.
Okay.
All right, head back, Mr. Ford. I'm going to handle Mr. Cobb's other case, and then we'll see if y'all can work something out.
Thank you, sir.
All right.
Now, just the Ricardo Bryan case, I don't know which prosecutor is doing this receipt.
Ricardo Bryan, let's pull that up. It's
Yeah.
2018 CF 1425. And I know he hasn't been transported,
And I wrote your JA.
and I read it all.
I tried to figure that all out. So
I just want to kind of figure out where we're at with it.
there's two parts of his coming back from the DCA. You have to resentence him because the DCA ruled that his sentence was illegal. And then,
Well, don't I have to, wasn't there an issue about the motion for new trial and him
Right.
being represented?
that's what I'm trying, if he's going to be resentenced favorably, he's willing to withdraw the motion for, that's what he told me, for new trial. So I think that when.
I think I have to address the motion for new trial before I can address the sentencing. I understand the gamesmanship, not by you, but what you just
Right, yeah.
stated. But, so I understand that, but I don't think, again, I'm going to get involved in, well, this is what I would sentence him to if he doesn't withdraw his plea or get a new trial. Or
Well, you know,
this
he
is what I
could
would-
I could talk to the state a little bit about parameters to get a feel for what they're
What was
gonna
he
call it.
sentenced to begin with?
Like 30, 35 or 30, something way, way out there. Everything was run consecutively. And it's probably something normally would have gotten.
But doesn't the remand from the DCA addresses that specifically as to what couldn't be done? It's been a while since I've read it because we've had this case going for quite some time.
Said you couldn't, based on his situation, those could not run consecutively.
It was like an HFO and,
And he ran them consecutive. He had two counts that were both HFO, and then he ran them consecutive, and they have to be run concurrently.
okay.
That seems like a fairly
It's supposed to
simple.
knock- What I think it does, based on what I read from the one time I read it, I think it's gonna be 10 years off of what, I think it says to 35 or 37, and I think it's gonna knock it down to 25, I think, because we're gonna have to run them concurrent. That's my limited knowledge.
All right.
Thought it was a wee bit less than that, but I might be mistaken. And while the judges, Your Honor, you're looking that up, he has been moved to South Florida to deal with some additional charges. I think that we could resolve this with him appearing by Zoom. I didn't have time between yesterday and today to get in touch with his new DOC facility. But instead of having to transport it from South Florida here and then back, I was going to ask the court if we can allow him to appear by Zoom. I think we can handle the issues that were raised by the DCA and his motion with him being on Zoom. It'll be easy that way.
If he's willing to do that, wants to do that to make it easier and it actually might happen for once, because I think every time we've transported him here, he's actually got here, he wasn't allowed to bring his legal materials with him. And then it's been a mess. But if y'all think that you can get that done, and so we can at least he can be present so we can discuss the substantive issues, I'd be happy to do that. But otherwise, I'd like to get a final hearing on this, one way or the other. If it's going to be resolved in some way, great. If it's not, let's have the hearing, I'll make the determinations as to his new trial or not. And then I'll certainly make sure any sentence is, number one, legal and complies with the DCA's opinion in reversal and remand.
So I think maybe we just need to just get us a date, and then I will prepare everything necessary for him to appear by Zoom. And, then I'll talk to the state, and if we can work something out before we come to the final date, we can get it worked out.
So do we want to do almost like a status date?
Like this, like we did now?
Yeah, but with him present?
Yes, sir.
Either on Zoom or here? I just don't want to transport him here unless we know it's going to be the final hearing, because even when I've said keep him here, he's been transported back.
So yeah, that status date will be great.
Why don't we do July 30th for the status?
That'll be in the afternoon, correct?
If you would like that, yes.
If I could do it in the afternoon, because I may have a
2
trial that
o'clock.
bleeds over, okay?
And then if you have some different ideas before that date, if y'all want to send me something, so I know what I'm
Yes, Your Honor.
walking into on that date.
And you, Mr. Seek, you are the prosecutor.
Yes.
Yes. Sorry for bothering you, Marshall, about it.
You're fine. I read it. I knew
It
what
might
was
change by
about.
tomorrow anyway, so.
All right. Now, who am I dealing with regards to Ford?
That's me.
Okay.
Okay.
Give me a second, I'll go talk to Mr.
All right,
Bowman.
just tell me when you're ready, and I'm going to handle the other few that we've got.
Just still sitting up there to plea. I don't know how long you need
I don't know. Mr.
I'm
Williams?
ready on Ms. Nielsen whenever.
Nielsen?
Yes, Leslie, or excuse me, Holly rather.
Molly.
I don't have my glasses on and my eyes are tired.
Airplane and Naked Gun.
Call me Shirley.
Let's not start.
Yeah, I
To be honest,
could go all
it
day on
it
that.
didn't register until I saw Mr. Perry start laughing, and I was like,
Mine was actually in the news.
Who's your friend?
Well, he only had a small bit part where he was
is that Mr. Epps?
Yes, Your Honor, I think it's Landon, I guess.
It's a misdemeanor plea?
No, Epps is here, he's in the back. I'm asking them to bring out.
I'm just gonna get your fingerprints, sir.
Do you need a score?
No, I've got one. Okay. Yeah, I went back to the office and printed some out.
All right. Ms. Nielsen, here you go.
Yes, ma'am. All right.
Thank you, sir.
And that would be each count concurrent, Judge.
It's fine, when I looked at it the first time, it showed 3 counts, and this was only 2, so I wanted to see the actual information, so I know what the counts were. All right. All right, Ms. Nielsen, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Holly Beth Nielsen, 5/18/87.
You pronounce that Nelson?
Nielsen.
Nielsen, okay, I thought you said Nelson. All right, ma'am, you're here in 26 CF 880 where you're charged with, is it principal to witness tampering?
That's what I got, Judge. Well, Judge, when you look at the facts, she's a principal to it. The other person's the one
But
who
still a
reached out. She
third-degree
gave him a
felony.
phone. Yes, sir. The principal rule applies as always.
I just wanted to make sure. All right, and then unlawful use of a two-way communication device. Both of your charges are third-degree felonies, Ms. Nielsen, punishable by up to 5 years in state prison. Do you understand that? All right, I've got a plea and sentencing agreement that would have you plea as charged. In return, the agreement you made with the state is that you'll be adjudicated guilty, so that's 2 felony convictions. Time served, followed by 2 years of probation, $515 court costs, $150 public defender fee, and waive costs of supervision due to the fact that you've been declared to be indigent. Is that your understanding of the agreement? Is that what you want to do here today? And have you had enough time to go over this agreement with your lawyer?
Yes, sir.
All right, and did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's representation and advice in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? All right, has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea other than what I've read to you as far as the agreement? And you understand by entering a plea, there won't be a trial of any kind?
Yes, sir.
And you understand that makes you waive all of your trial rights, which start on the bottom of the first page and go on to the second page of that agreement you signed?
Yes, sir.
And you understand you're waiving any potential defenses that you may have?
Yes, sir.
And you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? And based on all that, what are your pleas to the principal to witness tampering and unlawful use of a two-way communication device? I'll accept your no contest plea as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty on both counts. Time served, followed by 2 years probation to be served concurrently, $515 court costs, $150 PD fee. I'll waive costs of supervision. Anything that I've missed, other than this is a guideline sentence, she scored 32.8 points.
No, Your Honor.
Hearing nothing else, Ms. Nielsen, I'm going to have you meet with probation, who's sitting there behind you. Then you come up here to get your fingerprints, and they'll head back and I'll process you today. All right, thank you, Ms. Nielsen. Good luck. Oh, you also have 30 days to appeal, if I didn't say that.
Judge, we had talked about Mr. Krivic early, and the court signed the order on him, I guess, yesterday. I don't recall, though, when did we set him for? Was it 7:30?
I think so.
Okay.
Yeah, he's already off my docket, so I'd have to look him up.
Yes.
All right, what do we have? Mr. Riasti? Come on up.
Joseph Riasti for Christian Alexander Douglas, who's before the court, 2023 CF 111C.
Let's wait for him to actually come out, Mr. Riasti. They're getting him over here. Ms. Rivers, how long is Rudd going to be? Did y'all figure something out on that, or? Okay.
Maybe 5 to 10 minutes.
Can we do the one last bond hearing, then we'll do yours, and we'll do Ellis, and I think that's everything. All right, Mr. Douglas is here in 23 CF 111, where we're supposed to be here for the motion for new trial. I guess there's some issues with getting the transcripts. I read your motion, Mr. Riasti. What it didn't contain is any sort of relative dates as to when these things were being requested and when they're being done. Go ahead.
The transcripts have been requested. I've worked through all of the issues with Ms. Morell, who is the supervisor for the First Judicial Circuit official court reporters, and Patricia Hitchcock. She has agreed, now that I've gotten through all of that, Patricia Hitchcock has agreed to do the transcripts in the
Unofficial transcript of the trial because it's not for purposes of appeal.
I don't know what constitutes official or what constitutes
Official means it's
unofficial.
done by the court reporters who work for the circuit as opposed to a private person.
So she's agreed to do that.
She'll
And-
still swear to that it's an accurate transcript. It's just the official one is not done until there's an actual direct appeal, and then
Yes,
the
sir.
official court reporter does it and sends it to the district court of appeal and files it here.
So I filed the motion without filing it, the way the JAC likes it is to file it with the pleadings. So I filed the motion to incur costs with the JAC, and they gave me back an interim. They said this is not a response, but we want to know whether or not it's expedited or not. And I've already spoken to Christian Lakes directly with regard to this. I told him I would wait to respond to that.
Sorry, you spoke to who?
Christian Lake, who's the attorney that decides whether or not the JAC is going to object to
Okay.
trying to make sure that because the only way that, Patricia Hitchcock said that she needed approximately 2 months to do the transcripts now that she knows exactly she has the entire gamut of it all. And so that's why I suggested a date in early.
So does she have all the discs already?
She has pulled the discs with regard to, because she had to, one of the reasons why it was delayed is that I gave her a list of all of the pretrial dates and all of the trials and all of that, everything that I wanted to have transcribed. She had to pull all of that stuff and go through it to determine basically what the page numbers were gonna be. So it took her a while and longer, and I kept on going back to her saying,
And that was my question is, because the trial that we're talking about happened in November.
Yes,
It's
sir.
now almost July. And so I want to find out, not to assign any sort of culpability or blame or accountability, but I just need to know how this process works. Because obviously, our court reporters are pretty overwhelmed. Even the private court reporters are pretty overwhelmed. But I'd like to just make sure everyone's staying on top of this, so we're not, 2 years in and still trying to do something that should have happened 3 months in. I understand things can get delayed because of the lack of resources, but I want to make sure everyone's doing what they can to make sure they're telling or requesting things to be done in a diligent manner.
So I have the motion to incur costs completed. And I believe that based upon my discussions with Christian Lake, that when I respond that I do not need expedited transcripts, and it's only the $7.95 rate, that there will be no objection, and Ms. Hitchcock can begin immediately. That if we set the hearings for late August or early September, then everything will be done and we'll be able to resolve the case.
As far as the hearings, you're referring to the actual hearing on the motion for
The
the
actual
trial?
hearing on the motion, yes. Not, and if Mr. Lake and JAC ask for a hearing, I'm required to give them 25 days' notice, and that would delay it another month, basically. So the long delays have been Ms. Morell's response to your original order directing her to transcribe the proceedings. She reviewed it and said that they didn't have to comply based upon the fact that they were only obligated to do the transcription in that form or fashion upon direct appeal of a sentencing. And she made that specifically clear to me. Then I gave I gave it all to Ms. Hitchcock.
Again, Mr. Rios, I've read your motion. I
Yes.
understand the issues. It's
Those were
just, there's no dates in it. So I don't know if these conversations were happening one day after the other, or no one was responding for a month or two at a time. That's my concern, because these conversations should have been going on pretty fluidly as opposed to, you know, again, we're
The first delay was.
close to 8 months since this trial, or actually more than 8
Give you the
months.
dates, if you wish. The first delay was Miss Morel's delay, which was approximately 3 weeks after the order was issued. I received a response approximately 3 weeks later saying that they weren't gonna transcribe. Then I immediately did a very long request for an estimate for Ms. Hitchcock, and the delay she held that estimate for approximately 4 weeks, which made it almost impossible.
I understand. You understand, Mr. Douglas? Okay. All right, the state have anything they want to bring up? Ms. Leone, anything you want to bring up?
No.
I'm just trying to get to, you know, to finalize the case, one way or the other. All right. So, as far as dates, you said end of August, early September. I've got August 27th, then I've got September 3rd. My concern about September 3rd is I'm on duty that week, which means I can't be in a situation where I'm here till 7 o'clock at night on a Thursday because I have to handle so many other things that come in as emergencies. I try to get my duty week set where I'm not in the crazy criminal docket week like this one was. So after that, I could probably do September 10th.
September 10th would be the best date to give Ms. Hitchcock the amount of time. I told Mr. Douglas that I was requesting one actual physical copy, or at least one copy, so that I would get the physical copy to him, and then we could all work off of PDFs.
Okay. All right. State have any issues with that date either?
No, Your Honor, that's fine, the 10th.
All right.
It's okay.
The hearing on the motion for new trial will be September 10th at 2 o'clock. If there's any sort of slowdown, we think that's not going to happen, I'd like to know about it as soon as you do.
I should have the order on the motion and the order to you forthcoming.
All right, thank you. Anything
That's all I have
else?
before Your Honor.
All right, thank you. All right, Mr. Powell's, or is there only one of you here now? Or is that Mr.'s Powell? How do you say that?
Dixie's out in the hallway. He's around somewhere. Mrs. Thacker, you come on. Judge, could the state and I approach on an issue real quick?
Sure.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, let's go forward with our bond hearing on Mr. Thacker. Mr. Thacker is here on 4 cases, 25 CF 2263, 2279, 2338, and 2444. Mr. Powell, go ahead.
Thank you, Judge Bo Powell. For the record, there are 4 cases pending. Judge, 25 CF 263 is a grand theft auto, and 2279 was a burglary of a structure. Those cases are same offense, date and location, 2 different cases, so the timelines are kind of intertwined. But 3 of these cases, the bond was revoked for a license invalid tag, attaching tag unassigned. Mr. Thacker did enter a no contest admission, which resolved that case. The testimony we wanted to present today is primarily we're asking the court to reinstate his bond on those cases. He does have, there was kind of a time frame where he was evicted and didn't have a place to stay. We've arranged that where he's going to be residing with his brother. So we were asking the court to reinstate his bond with whatever conditions you deemed fit, and let him reside with his brother, whether it be on a GPS monitor. The state and I have been in plea negotiations, but we are completing discovery. As far as, like I said, this possession charge, this was a older, I guess it was an older offense date based on surveillance video. Mr. Thacker was not found necessarily in possession, but it's based on video surveillance from Walmart. And so the main issues, he's in jail, was the tag violation, and that's what's revoked his bond. So we're asking the court to reinstate his bond and put him on a GPS monitor while we complete discovery.
All right, any other evidence or argument, Mr. Powell?
Judge, just his family is here. He has been a lifelong resident of Okaloosa County. Like I said, at the time, he had been evicted. and didn't really have a place to stay. We've corrected that issue. He's going to be residing with his brother. And I will say, I don't have a whole lot of information, but part of the grand theft did, I guess, pertain to, there were some statements about it, Mr. Thacker believing it to be his vehicle. There was a pending case, and I don't have a whole lot of information on it, but Mr. Thacker is the victim, or was the victim, in a grand theft auto case, and that's in 26 CF 873. So somehow that's kind of intertwined into this. But other than that, Judge, we're just asking you to reinstate the bond with whatever conditions you deem appropriate.
State.
Your Honor, the case in which Mr. Powell refers to Mr. Thacker as a victim was null pros, just for the record. As the court is probably aware, the defendant has a very extensive history. Yes, he's been a resident of the Okaloosa County. However, his history goes back further than when he was made a sex offender back in 2011. He was designated as a sex offender, and because of that, Your Honor, it's very important that we keep track of his whereabouts. One of his new charges that's pending that he received while out on bond for the other charges is a failure to register. He failed to register his residence, and he failed to update his driver's license. He was, in essence, MIA, for lack of a better word, unaccounted for from the 26th of November until the 8th of December, at which point he then registered a temporary residence. He didn't even register a permanent residence, so there's still a great degree of instability. As I mentioned, this is his second failure to register. He has a history of felony batteries, DUIs, resisting, giving false names, possessions of controlled substance. His guidelines are 78.075 months as a minimum, up to 25 years for the charges that he's currently facing, and those are, at this point, 4 different cases. And as I mentioned, 2 of those counts are failure to register. Based on the fact that he is a sex offender and he does continue to violate basically while his cases are pending, we're asked the court to deny the motion for reinstatement of bond.
So maybe make sure I understand here. So the third of the 4 cases timed sequentially was the 2338 case. It's a possession of a controlled substance. He had first appearance on November 25th. Is that right?
I believe the
Yes, Your
offense
Honor.
date was October 17th.
There is a note, Your Honor, on that first appearance that does indicate that it occurred prior to the other pending charges of the burglary and the grand theft, but.
Oh, I understand.
Right.
But then he got a bond on that case at that time, did he not?
It appears that he did, Your Honor, based on the
There's a
court
surety
records.
bond filed on December 2nd. And then his newest charge, which is a 2444, the failure to register.
There's a $3,000 per count bond on that. I couldn't see if it was revoked in that case. I don't believe it was. I think it was just the other.
Well, I'm trying to figure out the date is when they relate to each other, those last 2. So let me.
Can clarify for the court that his failure to register charges are actually in the time frame while he was out on the bond for the other cases.
Would he have been in jail for a portion of that? So he's charged November 26, 2025 to December 8th, 2025, that he didn't register during that time, but he would have been in jail for part of that, right?
Didn't appear, but as the court's aware, we're having trouble seeing the court lists.
And that's why I'm partially asking the question, because it's hard to track like it used to be. You could
I
see
believe that-
everyone's ever arrest and their release date, and you could easily find that information out now, and now it's just.
That's what I had looked up, or was trying to look up when I found the information about the hold that was.
Sure.
Sidetracked me a little bit.
It's appear that the bond revocation, at least from my notes, may have been on 12/12. So that would have been after charges that we.
I guess my point is, so he looks like he had first appearance on the drug charge, which I know happened in October, but he was arrested November 23rd or 24th. Based on his first appearance, paperwork was signed on the 24th of November. And then he got out on December 2nd. November 25th to December 8th is when he's accused of failing to register. So I'm just trying to figure out, how much of the time that he didn't fail to register is because he was in jail, but if he got on the 2nd and he didn't register again until at least the 8th.
Actually came in on the 9th, is what the record should reflect.
Okay.
So he had 48 hours.
And so more than 48 hours went by.
Yes, sir.
So those new law violations of failure to register would have happened while he was on bond for the first two cases, right? So I guess my point is, when it's a tag issue on a car, or we had one earlier with a no motorcycle endorsement as the reason why someone's bond gets revoked, that's one thing. But failure to register as an offense that's been allegedly committed while on bond is a little bit different.
Judge, I will just say, he did register on the 9th. I do know the landlords, the Ansleys who were his landlords and employers, but they did evict him at some point in that time frame. That's about all I can tell you at this point for.
But even when someone gets out of jail and they're homeless, they have to report, right? So what you're saying might be potentially mitigating at some point. What I haven't heard yet is anything to tell me that that's not the case as to what happened. I'm not finding him guilty of anything here today, but I'm trying to figure out what's happened in order to determine if I think he should have a bond.
Understood, Judge, and I will say, his brother is local, and we've arranged it for him to live there, whether it be on GPS or whatever you deem fit. And I think letting him have that opportunity could also be mitigation for the state if he's compliant with strict conditions of bond.
And I understand that, but again, he's allegedly, there's probable cause that's been found that he's committed some actually serious offenses while out on bond in the other cases. This is not just a tag not assigned, which is still a crime, but I can look past those to some extent. A failure to register because he got out of jail and didn't register for a week, I don't think I can look past that.
Just one.
Anything else, Mr. Powell?
Just that, if my timeline, I was trying to find out when he was actually evicted. I believe, I'm actually not 100% sure. I think it was around the 26th of November when he was served with the ejectment or whatever the paperwork was. I believe I saw that in the report.
But he would have been in jail at that point.
Correct. So, I don't have.
So the issue is, what did he do when he got out of jail? And I'm not asking that question that I'm asking for an answer, but just kind of pointing out the issue is, from everything I've seen, he failed to register for about a week after he got out of jail. And again, even if someone's homeless, they're required to report.
Understand, Judge.
Your Honor, if I may, I think.
The amended final judgment of eviction was filed on November 25th. Anything else?
We just laid that issue out in the paragraph 1 of the motion, so I was going to point out.
Okay.
And he did his truck was stolen and the paperwork was in his truck. We-
And you know what? I don't even want to get into
Yeah, we-
it. His truck was stolen, so he allegedly broke into another truck. It's just, because he thought it might be his. It's, all right. Anything else?
No, sir.
Motion is denied.
We do need to address, I guess, our next court dates.
August 26th, 9 o'clock. Yes, pre-trial. If something else comes up, you can show me that my kind of recitation of these facts as I've gone through it is wrong. I'm happy to have a bond hearing where you present that evidence. I mean, you're not supposed to have any, and that's a substantial change in circumstances, but tell me what those circumstances might be and I'll listen to it. But at the end of the day, there's pretty serious offenses committed while on bond is the allegation, and probable cause was found, and that's why he's being held. Thank you.
Thank you, Judge.
John, could we just do a one-page letter explaining that and let the state respond?
You can put a one-page motion in, and I'll certainly consider it at a hearing. But I don't think I can just read a letter from one side and make a decision. Thank you, Mr. Powell.
Thank you, Judge. Have a good afternoon.
You too.
The motion with Ellis is out. I don't know if this.
Is that the only other thing we have left?
Yes, Rudd, sentencing,
Oh.
Ellis, whatever Landon's doing with him, and I see Mr. Cobb standing for Ford, I presume.
You presume correctly.
Oh,
I would assume that will be relatively quick, or no?
Yeah, I need to just pass it on and move on.
All right, come
I'll figure out
on.
who I'm dealing with.
Okay.
do I need him out for what you're about to do?
Yes, I would say yes.
Yeah. Madam Clerk, I do have a question. I see on the docket, I see two VOPs, actually. That's what I got a little bit confused, a 766 and a 765. I just want to make sure we're dealing with, like, I have 2124, which is the 25 case, and I have two VOPs, 766 and 765. And they both show reopened violation of probation, so.
And there seem to be two VOPs. Where are we at with this?
Well, sentence, so they were talking about the wrong.
And Judge, after spending some time looking at it and talking with him, I have both Fords. I have two different gentlemen named Ford, Kelvin Lee Ford and Jeremy Lynn Ford.
Yeah, Jeremy's not the one.
Jeremy Lynn is the one with two cases, has a 36-month offer onto it. Kelvin Lee Ford has three cases. Two of them are VOPs, and one of them is showing as a new law, but for some reason on my computer, it's showing as a VOP as well, and I don't understand how they did that, but I obviously would pursue the two VOPs prior to doing the new law violation. But he does have a significantly higher score and a significantly higher proposed sentence.
I just
don't
told
believe
you.
it's
So
10
this
years.
36 or 38 month, that's not accurate.
That is not accurate. That was for Mr. Jeremy Lynn Ford. That was his score.
That's my case, Your Honor.
Kelvin Lee Ford,
I know we had 3 Fords on the same day.
Yes. and I apologize for mistaking which Ford was which.
Set it for a violation of probation evidentiary. Correct, Mr. Mole?
Pardon?
Going to set it for a violation of probation evidentiary hearing?
Absolutely.
Is the VOP based solely on the new case? That's the way I'm seeing it.
I believe so, Your Honor.
All right, thank you, Mr. Berry.
I think that was all that was.
That's what I see. I just want to make sure I'm not missing something.
Yes.
All right, so what do we want to set as cases on? There's the VOPs and there's the new law.
I would prefer to do the VOPs first. Obviously, it's a different standard and a different issue with VOPs as opposed to having a proven case.
Oh, I understand. Mr. Cobb, what are y'all wanting to do?
We can set it for a VOP evidentiary hearing, and then Mr. Mull and I will get together and discuss a possible resolution, but I want to get this moving and get that resolved as
What about a potential trial on the other case?
I would assume we'd be ready to go to trial on that, the September trial week.
But he doesn't want to continue it. Right.
And I'm in a position, that if I ask and request for a continuance, it's going to create conflict between Mr. Ford and myself. I am aware of the facts of the case. If he wants to go forward and have it set on the trial docket, I'll respect his wishes. I understand, and I'll do my best to catch up to speed.
This is what I'm doing, and y'all can figure it out from here. I'll put it on the 29th, which is Monday. You can appear by Zoom, Mr. Cobb, like I stated, for docket day. 7/13 for the trial week. Any issue with putting the VOP on the 9th of July? Just 2 weeks.
No issue with me.
All right. July 9th will be the VOP hearing at 2 o'clock. All right. There you go. Everything's set and there's no continuance.
It does look like there may be two.
There definitely is, 765 and 766.
Yeah, I think that the VOP affidavit was filed under correspondence, so it never got
That's-
set for a date.
That's what I'm finding. There's a bunch of things called correspondence that.
So there are the two VOPs. Gotcha.
All right, thank you.
Thank you, Judge.
All right.